Hi, I'm Heather Scott. I'm a partner at Gill Jennings Every, which is an IP law firm in London and Munich. And today I'm going to be talking about intellectual property in the fashion industry. I'm going to be talking primarily about how to protect your products themselves. And in the second part of this talk, my colleague Alice Anderson will be talking about how to protect your brands. So very often when people think of intellectual property, it conjures up ideas of scientists in labs or heavy engineering or software code, for example. But fashion too is all about new ideas. Indeed, it relies just as heavily on creativity as different fashion brands vie to become the next big thing that everybody wants to be seen wearing. Every new dress, every new pair of shoes or handbag is an expression of a designer's thoughts and ideas. And this, the expression of an idea, is intellectual property. And there's a huge amount of value in it, as well as in the brands which tell the consumer where a particular product has come from. Intellectual property rights are legal mechanisms which exist to protect that value. They can be used to prevent your work and creativity being exploited by counterfeiters and copyists. So in this sense, IP is needed and used by the fashion industry in just the same way as it is in the technology sector. However, the strategy needed to police that IP effectively in fashion is very different. And that's just because fashion moves at a much faster rate, outputting whole new collections of items just every few months. Some of them have a really short shelf life too. So your IP strategy needs to take account of that. And we'll be looking at ways you can achieve that as we go along. So I'm going to look in more detail at how to protect the products themselves. And by products, I really mean anything that's a physical object that you produce. So some obvious examples will be the clothes themselves, like this dress, also accessories like these sunglasses or handbags. Footwear is another major category. Something maybe a little less obvious is the pattern on fabric itself, irrespective of what garment it might be made into. Then also things like jewelry. And this is an example of a belt clasp by Gucci. And I use this to illustrate that you don't need to protect the whole of a product, like the whole belt, but sometimes it's a good idea just to protect a particular part of a product. So copyright is one of the intellectual property rights which might provide some protection for your products. It protects original artistic creations. One good thing about copyright is that if an article qualifies for it, then copyright arises automatically. There's no registration process and you don't need to apply for it. Instead, you must keep detailed records showing how and when you created the design so that you can show them if you ever need to rely on copyright in the future. Another positive is that copyright has a long duration. For instance, in the UK, an artistic work is protected from its creation up to 70 years after the death of the author. Less positive, as the name suggests, copyright can only be used to stop actual copying of your product. So it's not a monopoly right. This means that to successfully enforce it, you will need to prove that the other party actively copied your product. And so they didn't just come up with the same thing independently. However, if the copy is pretty much identical to your own, then that will usually be reasonably straightforward. The big problem with copyright is that as UK law currently stands, you can't assume that just because something is your own original creation, it necessarily attracts copyright. It also needs to fall into one of certain categories defined in the UK's Copyright Designs and Patents Act. And the only category which is really relevant here is that called work of artistic craftsmanship. Now, traditionally, this has been interpreted as meaning, say, one of handmade items, such as, for example, a bespoke designer gown or a hat of the sort that you might wear to Ascot. It wouldn't usually cover, say, high street fashion items. However, this does seem to be slowly changing. There have been some decisions from the European Court of Justice recently, which suggest that an article shouldn't have to fall into a particular category in order to be protected. All that should be necessary is that it is deemed original. The most recent one of these is the Cofamil case, which I mentioned on the slide there. This related to some genes made by G-Star Raw, and there the ECJ confirmed that it shouldn't matter if they fall into a particular category or not. The test was simply originality. Now, there's been a recent case here in the UK courts, which was Response Clothing versus Edinburgh Woolen Mill. And this related to the fabric pattern, which is shown on the slide. And in this case, the judge appeared to apply perhaps a lower bar to determine whether this fell into the category of works of artistic craftsmanship, and decided that it did. Reading between the lines, that may be in order to bring UK law closer into line with the ECJ's judgment. However, it's really uncertain about how UK law is going to develop in this area, particularly in view of Brexit, because after the 1st of January, the ECJ is going to have no influence on UK law. So for that reason, it's best not to assume that copyright will protect your products. It might be available as a last resort, but don't rely on it if you can avoid it. So moving on to designs. This type of IP protection doesn't suffer from the same problems as copyright because it is available for all types of products. There's no requirement for it to fall into a particular category or to be considered artistic. And this makes it applicable to the whole fashion industry, from the catwalk to the high street and everything in between. Designs protect the appearance of a product, so they enable you to stop other companies from making copycat or look-alike products, irrespective of what brands they are sold under. Now, if they also happen to be carrying your brands, then that would make them counterfeit products, and Alice will be talking about that in the second part of this talk. As we'll see, there's more than one type of design protection. Some give you monopoly protection and others don't, and the duration also varies, but it's shorter than for copyright. The validity requirements are also different to those for copyright, and they do tend to be a slightly higher bar than the originality test in copyright, but they are by no means insurmountable. So the first type of design protection that I'm going to talk about is UDR, which stands for Unregistered Design Right. And as the name suggests, this is something which arises automatically upon creation of a qualifying product in a similar manner to copyright. Another way in which UDR is similar to copyright is that it can only be used to stop actual copying of your product. So once again, it's not a monopoly right. And to enforce it, you need to be able to prove that there was actual copying. Now, just to complicate matters, there are actually several UDR regimes which cover the UK at the moment. They all exist in parallel, and which one is going to be most useful to you just depends on the particular circumstances of a case. There are two main systems, and the first one is what I'll call British UDR. This one is set out in the Copyright Designs and Patents Act, and it usually provides for up to 10 years protection from the first marketing of a particular article. And this is the longest term offered by any of the UDR regimes. Unfortunately, it only covers three-dimensional items, so you can't use it to protect something like a fabric pattern. The design also needs to originate either from the UK or a select few other countries. The criteria for British UDR to arise is that the article needs to be original and not commonplace, but this is a reasonably low bar to meet. Now, European UDR is based on a European directive, and this has a much shorter duration, only 3 years from the first disclosure. So for instance, usually the first sale. That disclosure has to have taken place in the EU. So if the first disclosure took place somewhere else, then this type of UDR doesn't arise. However, the regime does cover both two-dimensional and three-dimensional products. The test for establishing whether European UDR arises is that the design needs to be novel and to have individual character. And essentially that means that it is different in some noticeable way from all previous products known to the public, so that it gives a different overall impression. And this is clearly a higher bar, but it can usually be met provided the item is clearly different from known products. So relying on UDR has its pros and cons. The biggest advantage is obviously that it arises automatically and hence there are no registration costs. This is really useful where a company has a lot of products that it wants to protect because they usually won't have budget to spend money on all of them. UDR can therefore be used as a sort of default protection for those items with a short shelf life or ones which are simply not considered to be very high value to the company. On the other hand, if you do need to rely on UDR, this can be really costly and difficult to enforce because not only do you need to prove that all of the qualification criteria are met, but also that there was actual copying. This assessment will be evidence-based, so it's really important that you keep good records. Another fly in the ointment is that a lot of uncertainty has been introduced to the European UDR system by Brexit. And as things stand, after the 1st of January, a first disclosure taking place in the UK will only get UDR protection in the UK. It won't trigger Europe-wide UDR. Now, I believe the government is looking to change that, but nothing is certain as yet. So just to illustrate the usefulness and some limitations of UDR, I have a couple of examples of cases that made it to court here in the UK. The first one is G-Star Raw versus Rhodey. And yes, these are the same genes that were the subject of the ECJ Cofimel decision on copyright that I mentioned earlier. However, in this case, G-Star Raw were able to rely on British UDR instead of copyright, which made their life a lot easier because they didn't need to prove that the genes fell into any particular category or were deemed artistic. The UK High Court agreed that G-Star Raw's genes were not commonplace and hence they were protected under British UDR and that Rhodey had infringed their rights. So G-Star Raw was successful. This case also illustrates the importance of good record keeping, as G-Star Raw was able to put forward really detailed evidence and witness statements showing their whole design process, and without that, they may well not have won the case. The second example I'm going to use is an older case, Lambretta versus Teddy Smith. And I'm using this to highlight some differences between the UDR systems. Now here, Lambretta's product was this zip-up jacket in this particular colorway. And the shape and configuration of the jacket wasn't new, and they didn't claim that it was. What they claimed was that the arrangement of colors was new and should be protected. Now, unfortunately, at the point of time in question, European UDR had not yet come into being, so Lambretta had to rely on British UDR. But as you may recall, British UDR only protects three-dimensional items, not two-dimensional ones. So here, the UK court decided that the colourway was not protected, essentially because this was two-dimensional rather than three-dimensional. So Lambretta lost its claim. Now, the situation would have been different if European UDR had been available to them at the time, but even then it would only have protected their product for 3 years. So really what they needed was a registered design, and conveniently, that's what I'm going to talk about next. So as you've seen, UDR can be useful in certain scenarios, but there are others where a more robust type of protection is needed, and this is where registered designs come into their own. As the name suggests, to get registered design protection, you need to apply for it. But the process is quick, simple, and not too expensive, at least compared to patents. Typically, the application just consists of a set of drawings of your product, and in the EU and UK, it can be granted in as little as a few days. Design registrations are territorial, so you need to file in every country where you want to get protection. There are mechanisms to help you. So in Europe, for example, there's a process by which you can file a single application and get protection across the whole European Union. Of course, after Brexit takes place on the 1st of January, the UK will no longer be covered by that. So it will be necessary to file a separate UK design application in parallel to get the same coverage. Unlike copyright and UDR, a registered design is a monopoly right. So this means you no longer need to prove copying. And indeed, if a third party produces something that looks the same as your registration completely independently, that would still infringe. The duration of registered designs varies by country, but it's longer than UDR. So, for example, in Britain and the EU, a design can be maintained in force for up to 25 years. One really important benefit of registered designs is that it can be used as the basis for customs applications and takedown requests. Alice is going to talk about that more in the second part of this talk, but essentially it makes policing your IP much easier. So how do you go about getting a registered design? Well, the qualification requirements are the same as those for European UDR. So this means that the product must have an appearance which is novel and have individual character over all previous designs known to the public before your filing date. And it's important to note that that includes your own prior disclosures. And what this means in practice is that the default situation is that you must file the application before you disclose your product. Now, there are some countries which offer a grace period, allowing you to disclose first and file later. And for example, in the UK and Europe, there's a 1-year grace period. So provided that you file your application within 1 year of your first disclosure, it would still potentially be valid. But there are many countries where that simply doesn't exist. So China, for example. So if you might want to get protection in other countries, you may well need to file the application before making any disclosure. It's important to keep in mind that when you file the application, you don't necessarily need to register the appearance of the whole product. But as I mentioned earlier, it may be sensible just to file protection for part of it. So for example, the belt clasp we saw earlier, or say a zipper that you might use on multiple products. How you determine the scope of the design is simply through the drawings that are filed. That means that it's really important to get those right. And I'll show you an example in a moment where that didn't quite happen. So it's really important to get advice from a qualified attorney on this point. So let's look at the pros and cons of design registrations. Really, the only downside to them is that there is a cost involved. However, it's relatively low and it's always predictable. There's also mechanisms available if you have many designs that you want to protect. For example, by filing them in bundles can give you a cost reduction in the UK and Europe. Helpfully, registered designs can be obtained very quickly. As I've mentioned, it's possible to do so in a matter of days. So as long as you have the drawings ready and you get in touch with an attorney in the run-up to a launch, this doesn't need to slow down your plans. As I've mentioned, registered designs are a monopoly right of reasonably long duration, and importantly, they can be used in customs applications and takedowns to help police your IP. So whilst it may not be affordable for a company to obtain registered design protection for every one of their products, doing so for at least the key pieces in each collection is a really worthwhile investment. These are the ones that you hope to endure through several seasons and ultimately to become classic pieces. UDR will not last that long, so you really need a registered design in order to protect them. So just to look at some examples, I should mention first of all, there's all of the images I showed you earlier with the dress and the trainers and handbag, for example. All of those are examples of registered designs on the EUYPO website, so they have ongoing protection currently. And here are a couple of relevant UK court decisions. This first one, it was a case brought by Jimmy Choo against Tower Stone, and it related to their Ramona handbag, which is shown there on the left. Tower Stone essentially produced a cheaper version of the same thing. You'll see that there are some small differences between the two bags, but the court decided that it still amounted to the same overall impression. And as a result, they held that Tower Stone did infringe Jimmy Choo's registered design. Secondly, the trunky case. Now, this one, I'll admit, is probably on the edge of what you'll consider fashion, but I mention it because it shows the importance of getting the drawings right. So the drawing on the left there is one of the drawings from Trunky's design registration, and the one on the right is the defendant's product. Now, as you will see in the design registration, it shows the sides of the case as being plain and without decoration. And the defendant's product clearly has a lot of surface decoration. And the judge decided that because that was the way the sides appeared in the drawings in the registration, then the defendant's product did not fall within the scope of Trunky's registered design. And for that reason, Trunky lost its case as far as the registered design went. Now, it's clear to see that if different drawings had been filed, for example, as line drawings showing only the contours and not implying what the surfaces actually looked like, then the outcome may well have been different. So it underlines how important it is to get those drawings right at the start. Okay, so I'm just going to sum up with some practice tips in relation to protecting your products. First of all, work out your strategy in advance. And I'll suggest having different strategies for the core pieces of your collections and the other pieces that may be of lower value. For those core pieces, you really want to look to file registered designs, and you'll need to think about when those need to be filed, especially if you want to get any protection in places which don't have a grace period. You'll also want to think about whether it's appropriate to file customs applications or register that with an online marketplace such as Amazon. It's important to get advice on all of these points. Then for all of your products, it's really important to keep good records of the design process and of the first disclosure, just in case you ever need to rely on this in relation to UDR or copyright in the future. And finally, make sure you know who designed each item, if it wasn't you personally, and that their rights have been properly transferred to the company that's selling the product. That's to ensure that you'll actually own the IP and be able to enforce it in the future, should you need to do so. Okay, if you want to find out more about intellectual property, you can have a look on our website. We also have lots of other expert talks on our YouTube channel. Feel free to email us. Our email addresses are shown on the slide, or connect with us on LinkedIn. Thanks very much.